congressman and first libertarian congressman and very brief former libertarian presidential candidate, Justin Amash, announced this week that he is bringing a bill to the floor of Congress to end qualified immunity, which incidentally, Joe Jorgensen and I support 100%. In a letter to his colleagues, he wrote, Nope. He wrote, as part of the Civil Rights Act of 1871, Congress allowed individuals to sue state and local officials, including police officers who violate their rights. Starting in 1967, the Supreme Court began gutting that law by inventing the doctrine of qualified immunity. Under qualified immunity, police are immune from liability unless the person whose rights they violated can show that there is a previous case in the same jurisdiction involving the exact same facts in which a court deemed the actions to be a constitutional violation. And of course, because this law doesn't allow precedent to be set, there is no precedent. This rule has sharply... I added that last bit. This rule has... That's not on...
Hang on. We'll get to that. We have an entire history lesson to go through here.
Okay, good. This rule has sharply narrowed the situations in which police can be held liable, even for truly heinous rights violations, and it creates a disincentive to bringing cases in the first place. If a plaintiff knows there is no prior case that is identical to theirs, they may decline to even file a lawsuit because they are very unlikely to win. Even if a plaintiff does file a case, a judge may dismiss it on qualified immunity grounds and decline to decide whether the plaintiff's rights were violated, meaning the constitutional precedent still isn't established, and so the next plaintiff still can't recover. Like I was just saying, sorry. I kind of got ahead of him.
So... qualified immunity, you've been seeing it in the news a lot over the last week.
Yep.
And a lot of people, they know what it means. It means that the police officers and members of the government, they have immunity. It kind of doesn't matter what they do.
Right.
Let's see how we got here. And thank you to Chris Reynolds for all the help he gave me finding all of this information and explaining some of it to me. So after the 1871 case, which Amash mentions, allowing individuals to sue state and local officials, Pearson Verse Ray happened. Now, this was where members of a clergy, I believe it was a clergy group, of white and Negro clergymen on a prayer pilgrimage to promote racial integration attempted to enter a segregated interstate bus terminal waiting room in Jackson, Mississippi in 1961. This was illegal. They were arrested, but the law that allowed their arrest was found to be unconstitutional in 1965.
Okay.
They sued the officers who arrested them, saying their arrest was unconstitutional, but the jury found with the respondents, i.e. the police, because they could not have predicted the 1965 ruling.
Oh, okay.
This is how you can't really get false imprisoned by a cop.
Because they can never predict what the law is going to be in the future.
Right.
What a bunch of garbage.
In 1982, Harlow versus Fitzgerald, the Supreme Court held that the federal government officials are entitled to qualified immunity. They defined it. Qualified immunity balances two important interests: the need to hold public officials accountable when they exercise power irresponsibly, and the need to shield officials from harassment, distraction, and liability when they perform their duties reasonably.
Reasonably, key word there.
There's a bunch of reasonability and reasonably in this, and it is all very essential.
Yeah.
This means that the court granted all government officials immunity for violating constitutional and civil rights unless the victim of those violations can show that the rights were clearly established. This doctrine shields individuals from criminal prosecution and lawsuits as long as their actions in question were within the scope of their jobs, or a better way to say this is it is the doctrine that has allowed police officer after police officer to get off unscathed, murder after murder, abuse after abuse of innocent people in this country.
It allows them to simply say, I was doing my job and I thought that's what I needed to do.
Right.
I decided that it was reasonable.
Next came Malley versus Briggs in 1986. The court held that qualified immunity does not apply to a police officer when the office wrongfully arrests someone on the basis of a warrant. If the officer who could not reasonably believe that there was probable cause for the warrant, reasonability is determined by the action that an objectively reasonable officer would take.
Objectively.
Reasonable.
Objectively, as determined by that officer, which is the opposite of objectively. Sorry, go ahead.
You're fine.
That's called subjectively. In fact, I don't even have to use quote marks. When an individual who is specifically they are the ones who are potentially in trouble based on what they decide was reasonable, that is the opposite of objective. That is subjective. Sorry.
Then Anderson versus Creighton, 1987. The Supreme Court held that when an officer of the law, in this case, it was an FBI officer, conducts a search which violates the Fourth Amendment, that officer is entitled to qualified immunity if the officer proves that a reasonable officer would have believed that the search constitutionally complied with the Fourth Amendment. Now, again, this is relying on whether or not the officer is reasonable or based on its definition, its legal definition, which the definition of reasonable is just, rational, appropriate, ordinary, or usual in the circumstances.
As determined by the officer who will get in trouble if he or she says that they don't think it was reasonable. What do you think they're going to say? They're going to say what they say every time. They're going to say what you would say if you were in that situation. Yeah, it was reasonable.
Search. It was a reasonable search.
I had every reason to reasonably think that this was constitutional.
Yep.
You know what the easiest way for them to reasonably think that? They were ordered to do so, even if it was unconstitutional. Well, they told me to. Yeah, I assumed it. Why would I not think? Any reasonable person would think it was constitutional. So now, instead of police officers and federal agents and every other officer of the law having to apply the law to what they do, they just have to apply their own subjective idea of what they're doing, if it's reasonable to them or not. Well, I got news for you. If they didn't think it was reasonable, they wouldn't have done it. So unless they just flat out murder someone on camera, and even if they do that, but really murdering someone on camera is about the only thing they can get in trouble for. Just about anything else, they can conclude that they were reasonable in doing so.
I really wish we had kept that Trey Gowdy bit where he was saying, why does it take a video? I wish we had kept that.
I think I even have that. Keep talking. I think I still have that somewhere. Hold on.
Next, 2001, we had Saucier versus Katz. This gave us the Saucier test, which is a misnomer because it's not even saucy, much less saucier.
Pretty sure that's saucier, but okay, we'll do that joke.
Well, there was no way I could do that joke with saucier.
That's fair.
This states that early in a trial, if qualifying immunity is being questioned, it must be proven that first, a court must look at whether the facts indicate that a constitutional right has been violated, and if so, a court must then look at whether that right was clearly established at the time of the alleged conduct. So, like Spike said earlier, before I let you rant, because I'm going to let you rant after I do this segment, looking for court acceptable examples of this is so difficult, and the cases have to be spot on exact. Spot on exact. A case that's up for appeal is a case where last November in the Sixth Circuit U.S. Court of Appeals, they held that Tennessee cops who allowed their police dogs to bite a surrendered suspect did not violate clearly established law. The victim cited a case where the same court earlier held it was unconstitutional for officers to sick their dog on a suspect who had surrendered by lying on the ground with his hands to the side. That was not sufficient, the court reasoned, because the victim had not surrendered by lying down. He had surrendered by sitting on the ground and raising his hands. Because he didn't lie down with his hands to the side, because he sat down and he put his hands up, it was not the same thing, therefore did not qualify.
They will find anything that made it not the exact same thing to get it dismissed.
Another example for people who might be, well, that's one example. Another example, in February, the Fifth Circuit U.S. Court of Appeals decided a Texas prison guard who pepper sprayed an inmate in his locked cell for no reason did not violate clearly established law. This was because similar cited cases involved guards who had hit and tased inmates for no reason rather than pepper spraying them for no reason.
Qualified immunity needs to end. It just needs to end. This allows the cops to, as long as they don't do the exact same thing that some other bad cop did, or bad corrections officer or bad federal agent did, in the exact same jurisdiction, they can walk, even if it's determined that it was wrong, they don't get in any trouble for it. So I found the Trey Gowdy thing, and Matt, just to let you know, we at first will not hear the audio, but the listener will. So here is Trey Gowdy.
Background has confidence in. I guess my first question would be, why did it take the video? I mean, if you have someone who is jogging, who is unarmed, who is shot and killed by officers who aren't officers, they're not even law enforcement officers, why did it take the video? It makes me think back to the shooting in Charleston, where the police officer said he was acting in self-defense, and then the video came out. So I think what people of color want to know is, where is the justice before it's on video? Because most of this stuff is not on video.
Yeah. There's not really anything to add there. That's
no,
exactly
like he
correct.
nailed it. He nailed it. And I never thought that I would say that Trey Gowdy
nailed something 100%. No, he did. He totally gets it. Former was it state or federal prosecutor?
Federal, I believe.
Yeah, he's in South Carolina. Former prosecutor. He gets it. Because that's a whole other thing. They didn't arrest Ahmaud Arbery's killers because they saw the video. They arrested him because we saw the video.
Yep.
Which is interesting at a time when government is talking about trying to control what social media can and can't do, while at the same time making it illegal to be against fascism.
George Floyd's murderer, one of them, didn't get third-degree murder charges because they saw the video. It's because we saw the video. That kind of stuff has been happening for as long as law enforcement has existed. Right.
And in fact, there's actually some studies showing that the amount of police violence has been slowly going down, but we're seeing more and more of it. Part of the reason it's going down is because we're seeing more and more of it, and we're calling them on it. Back in the day, when we would hear about bad cases and simply assume that the police were in the right because they said they were, they don't have that anymore because everyone's got an HD camera walking around now. So it's a lot easier to catch I shouldn't say that, to catch police officers who, for whatever reason, choose to harm the people that they're supposed to be serving and protecting.
Now, potential good news. Potential. I'm not going to say it's good news. It's potential good news.
Potential.
This week, the Supreme Court might announce, and I was reading that it was going to be announced yesterday. Nothing was announced, and nothing was they didn't say that they weren't going to take it, and they didn't say that they were going to take it. But they announced whether or not I would hear one of the following next cases. There's 13 cases overall. We didn't include all of them in this. And officers who stole $225,000. A cop who shot a 10-year-old while trying to shoot a non-threatening family dog. Prison officials who locked an inmate in a sewage-flooded cell for days. SWAT team members who fired gas grenades into an innocent woman's empty house. Medical board officials who rifled through a doctor's client files without a warrant. County officials who held a 14-year-old in pretrial solitary confinement for over a month. A cop who body slammed a 5-foot-tall woman for walking away from him, which you would have seen in the videos before. Police who picked up a mentally infirm man, drove him to the county line, and dropped him off at dusk along the highway, where he was later struck and killed by a motorist.
This is a sampling, by the way, because, I mean, we're talking about qualified immunity. Just remember, this is stuff that officers and officials did to people just because they wanted to. So when we're talking about thugs and looting and rioting, these are people who do this and then don't get in any trouble for it.
Haven't yet. So
this is why we say this often on this show. This is why we're libertarians. I'm sorry. I know you're trying to finish your thing. Go ahead.
No, you're fine. The Supreme Court is supposed to be deciding on picking one of these cases for next session. Hopefully they do, because then there will be precedent and qualified immunity has a chance of going away through the judicial. There is a chance. I don't know if it'll pass. I think it really depends on RBG.
Probably
I have
so.
no idea if it would pass. I have no idea if it wouldn't pass. But there is a chance for qualified immunity to go away. And these cases that were on the screen, the ones that we didn't go into it, all of the links for all of these cases are
in the show notes. Yeah.
You can look up all of them. These are the cases that have allowed cops such as Derek Chauvin, who he had at least 17 excessive force complaints before he killed George Floyd. And I know he shot somebody else and killed him.
Yep.
But don't blame Amy Klobuchar for him.
Don't blame Amy Klobuchar. Definitely not her fault.
But these are the cases that allow cops to get away with their crimes.
Yep. Allow them to assault and rape and murder us and our neighbors as they see fit.
Right.
There is a study that was done in, I believe, 2003 on police officers and domestic abuse. 40% of police officers that were surveyed admitted to engaging in domestic violence against their families. 40% admitted to it. Not were convicted, admitted to it. Nearly half admitted to it. I will leave it to you to decide if this type of the way that law enforcement has been militarized, both in armament and tactics, has led police officers to be this way. Whether the type of people who are already this way become attracted to a job that is like this, that has been set up this way, or whether it's some combination of those things. But there is a tremendous violence and abuse problem among the people who the government grants the authority to essentially do whatever they want to us with little to no oversight. This is why we are libertarians. Because every single thing that we think is a good idea and should be a law is enforced at the barrel of a gun that is being held by the people who do this kind of stuff.
Right.
Steal, shoot a 10-year-old, try to shoot a dog that wasn't threatening them, lock someone in a sewage-flooded cell, fire gas grenades into someone's home that had nothing to do with whatever they were doing, going through people's client files without a warrant, holding a 14-year-old in solitary confinement for a month without trial, body slamming small ladies for walking away, taking a mentally deficient man, dropping him off at dusk where he gets killed. These are the people who enforce the things that you think are good ideas. This is why we are libertarians. So hopefully the Supreme Court makes the right decision here. Here's why. Justin Amash, Representative Amash's law, and I hate to say this, has almost no chance of passing. Do you know why? Because he's not a Republican or a Democrat, right, and they don't want him to have the victory.
Right.
For all the Justice Democrats right now and some of the small government, liberty-leaning Republicans who are saying that this is bad, almost zero chance of that bill passing. Because they don't want a non-Republican to get a victory in Congress. I hope I'm wrong. I hope it does pass. Or I hope that the Democrats reword what he wrote, pass it as their own thing, and or the Republicans, whatever. So hopefully this passes in some way. But the odds of them giving Justin Amash an independent, a libertarian, a third party member who apparently, at least as of right now, is not running for re-election, giving him that victory in an election year, almost no chance of happening. So hopefully the Supreme Court does the right thing here.
Akasha Nico, if I pronounce that wrong, I am very sorry, over on YouTube, posted, I heard the cop that killed George Floyd knew and worked, comments, hang on, knew and worked with Floyd for 17 years. Is that true? Sounds personal if true. Now, I don't know if they worked together for 17 years. I don't know if they knew each other. They did work at the same club in security together.
Yeah.
Over the past season, over like the past Christmas season or something like that. The owner of the club said both of them worked there. She said that the security team that they had at that club was so massive, there's a good chance that people who worked it never met each other. But she did say that they worked there at the same time. I have not heard that 17 years together.
Yeah, I haven't heard that. It might be true, but we don't know.
They did work at the same club, but the club owner did say, I don't know if they knew each other.
Yep. Here,
That's why we didn't report on it, is because the club owner said she didn't know, and he's not going to admit to knowing.
Oh, of course not. Now, we've had some people, especially in the last week, who've said, yeah, but what about what he did to get arrested? Well, here's the thing. It was nothing that warranted being slowly choked to death by a cop while you were already handcuffed. So let's establish that. Here's what it was for. Suspicion of using a fake $20 bill. Which he might not have, let's say it was fake. He may not have known that it was fake. He may have just, what's that?
That was exactly what I was going to say. He lost his job at the club because of COVID. He lost his job because of COVID. He probably only had
lockdowns. Yeah.
He probably only had access to X amount of dollars.
Yep.
He may have gotten that 20 as change. We don't know that he was some master counterfeiter, or not master since he got caught. But we don't know that he was that. He could have easily gotten that fake 20 and just thought it was real and gave it to somebody.
He could have very well. I mean, I remember seeing a study that something like 8% or 10% of money in circulation is counterfeit and people don't even know it. He might have not even known. But let's say he did. Let's go ahead with the assumption that he did it, that because times were tough, he was, counterfeiting money or using counterfeit money. Nothing that he did warranted what happened to him to be casually murdered like that. Oh, and by the way, that cop that murdered him, yeah, his wife, now it was before they were married, but his wife was charged with writing a bad check, $32 check. Now, she did pay it back, and she got, which was really all they had to do with George. No one murdered her, which is good. We're very good. We certainly don't wish any harm on her.
Filed for divorce, so I'm willing to bet that Derek Chauvin was one of the 40%.
Oh, has she filed for divorce?
Yeah. The moment he was arrested.
Really?
Yeah.
Well, 40% confirmed. 40% admitted to. Let me say something, not just because I am running for office, but because I have friends who are police officers. This is not an anti-cop thing. This is about what the institution of law enforcement itself has become, and the fact that until we remove the militarization of the police and qualified immunity and the war on drugs and the wars against victimless commerce like sex work, like drug sales and things like that, the police de facto, as a means of actually doing their job as currently stated, have to constantly aggress against all of us, even if they're doing so in a generally, peaceful and amiable manner. They are still committing aggression against us. And then when they act this way, they're committing violent aggression against us. And when they destroy our neighborhoods by corralling and harming protesters and driving them to violence and leaving the rest of the city for looters, they are committing negligent and violent aggression against us. And when they use that as a pretext to bring in the military and the National Guard, they're committing massive violent aggression against us. So this is an institutional thing. This isn't, oh, my friend is a cop, you must be talking bad about him. No, this isn't about your friend. This isn't about my friends. This isn't about my relatives that are in law enforcement. This isn't about your uncle that you love who is a cop. It's not about individual people. It is about the institution of law enforcement and the changes that need to be made because of the harms that institution is doing to all of us, especially to marginalized communities, communities of color, gender and sexual minorities, religious minorities, ethnic minorities, the poor of all colors, the homeless, immigrants, but all of us, really. It needs to end, and we need to put it to an end. And Joe Jorgensen and I have actually laid out ideas of dismantling the police to prison industrial complex, demilitarizing the police, ending qualified immunity, refusing to cooperate with in a law enforcement manner with states until they change their standards of operation for their state and local police in a way to make it to be more of a way that is in keeping with treating our neighbors like neighbors instead of the enemy and second-class citizens.
Justin Amash, if he gets his bill through, great.
Amazing.
Awesome.
Will be fantastic.
No way Trump signs it.
Nope.
If he can get it through the House, great. If
Trump will absolutely veto that. Yeah.
But Trump will veto it. So Trump wanted to expand on civil asset forfeiture.
Yeah, that's another thing that needs to end. Civil asset forfeiture, that's another thing that we will put an end to. And that is a top-down federal program. The states have their own federal civil asset forfeiture programs, but it is the federal government who dictates how all of those are run. It is them who are basically laundering the money, and it is or legally laundering, but still laundering the money. And it is absolutely a federal thing that can end at the federal level and work its way down to ending at the state level. If you take all of the confirmed cases of theft and put them in a column here, and then take all of the that happened in a given year and take all of the cases of civil asset forfeiture, which is when the government takes the property of someone who has been accused of a crime, not convicted, sometimes not even taken to trial yet, but accused of a crime, and they take all of their property at the very moment that that person could have used that property and money to defend themselves, and instead they use it to fund their prosecution. And if by some happenstance they get found not guilty despite all of that, they then have to sue to get their own property back, even after they were found not guilty. And of course, they don't have any money to sue to get it back because all their money's gone. So if you take all the cases of that civil asset forfeiture and compare it to all the cases of theft and burglary, civil asset forfeiture, there's actually more of that every year than there is private sector burglary. The biggest thief is the government, and that's before we even get into taxes. The biggest thief is government. That absolutely needs to end.